What is prison labor? Prison labor is the work performed by incarcerated people for the benefit of the state, private vendors, or internal prison operations, often for little or no pay and under rules that can make refusal a disciplinary offense. Put simply, it is labor extracted within a carceral setting, justified by punishment and rehabilitation, yet entangled with economics and history in ways that make many ask whether slavery's ghost is still among us. To see why that question has power, start with the law's foundation. The 13th Amendment to the Constitution abolished slavery and involuntary servitude, but it includes an exception for punishment of crime, provided the person has been duly convicted. That narrow clause opened a wide door. After the Civil War, Southern states deployed black codes and convict leasing, funneling largely black men into labor camps, mines, and plantations. Chain gangs paved roads and cut timber. Courts, invoking the punishment exception, generally upheld compulsory labor behind bars, even as conditions drew criticism. The rhetoric of rehabilitation often covered an economic reality. Prisons and private lessees profited. Incarcerated workers had no bargaining power, no right to strike, and almost no legal remedy. Fast forward to the modern era. Many jurisdictions still assign incarcerated people to maintain prisons, prepare meals, clean facilities, or manufacture goods for state agencies. Some supply outside markets through prison industries programs or vendor contracts. Wages can be measured in cents per hour, and in some places workers are unpaid. Refusing to work can bring sanctions, loss of privileges, solitary confinement, or extended sentences through disciplinary credits. When someone says chains we cannot see, they are pointing to the coercive structure that makes a choice to work illusory. Legally, how can this be? Courts typically hold that the 13th Amendment's punishment clause permits compelled labor after conviction. Minimum wage laws and overtime protections often do not apply to incarcerated workers performing prison-assigned tasks because they are not treated as conventional employees. The 8th Amendment forbids cruel and unusual punishments, so extreme conditions, dangerous assignments without safety gear, or deliberate indifference to serious risks can violate constitutional standards. But the line is high. As long as prisons provide basic protections and a colorable rationale, compelled labor remains lawful. The result is a stark asymmetry. The state may demand work, the worker cannot demand market wages, union representation, or typical workplace rights. Supporters of prison labor emphasize skills, routine, and restitution. Work, they argue, teaches discipline, offsets incarceration costs, funds victim compensation, and can ease re-entry by building a resume. Those benefits exist in some programs, especially where assignments are voluntary, credentials are real, safety is serious, and pay is meaningful. The trouble is variability. Too often, jobs are low skill, training is thin, and the link to post-release employment is weak. When the paycheck barely buys toiletries at commissary and the sanction for refusal is severe, the picture looks less like rehabilitation and more like exploitation. Race and power complicate the lens, because policing, charging, and sentencing practices have long produced racial disparities in who is incarcerated. A labor regime that compels work will predictably fall most heavily on communities of color. That is the historical echo people hear. Not the formal ownership of persons, but a system that converts the bodies of the punished into a cheap labor force, with profit and convenience aligned against agency and dignity. Examples clarify the stakes. Incarcerated crews fight wildfires in some states for token pay while risking their lives. After release, they can face licensing barriers that keep them from firefighting jobs. Prison factories produce furniture, textiles, or call center services that undercut outside competitors who must pay market wages and provide benefits. Inside kitchens and laundries keep institutions running, but workers can be disciplined for refusing shifts even when they are sick or injured. None of this equals chattel slavery. All of it inhabits the punishment exception's shadow. So is slavery's ghost alive in prison labor? The precise answer is legal and moral. Legally, the punishment clause permits compelled work after conviction. Morally, when labor is coerced, underpaid, and unsafe, When refusal brings punishment, and when profit rides atop punishment, the ghost feels very much alive. Exercising it does not require abolishing all prison work. It requires redesigning it. Make participation truly voluntary. Tie jobs to real credentials and apprenticeships. Guarantee safety standards, medical coverage for injuries, and independent grievance channels. Pay wages that reflect the value of the work, with portions reserved for savings, family support, and restitution. Ensure that private contracts do not depend on coercion, and open the books, sunlight, audits, and public reporting deter abuse. Curiosity to end. Several states have begun revisiting constitutional language on slavery and involuntary servitude and punishment. The debate itself is a sign of cultural shift. Whether those words change the daily reality will depend not on poetry, but on policy, on whether we choose rehabilitation with dignity over punishment powered by invisible chains. Above, I leave you more videos so you can keep learning law. Remember to leave us a like and subscribe.